thought the microphones weren't working then. Right, good morning everybody. We've got quite a short agenda this morning. It's very good of officers and members to turn out on a morning. It's -4 outside. Nice to see the roads gritted and the county council doing what it should be doing, and it's appreciated, particularly on the rural roads where life sometimes gets a bit difficult in cold weather. We'll start off, please, with apologies. Have we got any apologies?
Yes, thank you, Chair. We have apologies from Councillor Jack Abrahams and Councillor Jill Waring. Thank you.
Thank you. You didn't get any apologies from the final member, Robert Pritchard? Right, okay. Could you put his apologies in, please? Okay. And we'll go on, please, to declarations of interest. Have any members got any declarations of interest? No? Okay. And minutes of the meeting held on the 8th of December 2023. Moved. Seconded? Paul Snape and carried. Okay.
I wasn't present. Nobody else was present, so I will move. That's so seconded.
Right. Is this your first panel?
It is.
All right. Oh, welcome. I should have welcomed you at the start. Caroline Trowbridge is now on the committee, and I think Councillor Hudson's dropped off.
Caroline is also fully trained as well to be on the committee. She's got all the training, so it's great to have her on board.
Yeah, excellent. Can we use your microphone and then... Do you want to say that again?
It is great to have Caroline fully trained and now joining us on the committee.
My thoughts, sentiments entirely the same. Thank you. Right, so we've done the minutes. Thank you. And we'll move on to the one agenda item we've got, which is LF62G S53 Wildlife and Countryside Act, and it's an application to upgrade public footpath 18 Swinnerton to a public bridleway. And I understand, Laura, you're taking this. Thank you.
Thank you, Chair, members. This application is for the upgrade of public footpath 18 Swinnerton to a public bridleway. I can confirm that we have received no objections or representations from the local member. For the purposes of this report, the application route has been split into two sections marked A to B and B to C. The line of the route can be seen at Appendix B. Moving to the recommendation, which is that the evidence submitted is insufficient to show that a public bridleway subsists along the application route marked A to B on the attached plan at Appendix B, and that no order should be made in connection with this section of the route, and that the evidence is sufficient to show that a public bridleway subsists along the application route marked B to C on the plan attached at Appendix B, and that an order should be made to upgrade the footpath to a public bridleway to the definitive map and statement for the Borough of Stafford. The evidence of use takes the form of 14 user statements made by members of the public who claim to have used the route over varying periods of time. These are attached at Appendix C of the report. Some user evidence forms were submitted with the original application in 1996, and some were submitted in 2020. For the application to be successful based on user evidence, it will have to be shown that the public have used the route as of right and without interruption for a period of at least 20 years prior to the status of the route being brought into question, or that it can be inferred by the landowner's conduct that they had dedicated the route as a public right-of-way and that right-of-way had been accepted by the public. First, we will consider the section of the route marked A to B. This land is subject to Crown immunity and is owned by the Forestry Commission. Therefore, the statutory test will fail. Crown immunity is the legal principle in the UK that exempts the government and monarchy from some laws and legal proceedings, and so the notion is that statute law does not apply to the Crown unless expressly written to do so. As such, the application in respect of the section of the route marked A to B must succeed or fail under the common law. Common law is a judge-made law derived from case decisions and historical customs, or statute law is created by Parliament through legislation. In this tribunal of fact, it would namely be the Highways Act 1980 and the Wildlife and Countryside Act 1981. Under the common law test, proving a public right-of-way requires two key elements: the landowner's intentional dedication and their authority to dedicate, which rests with the freehold landowner. This test is based on somewhat similar criteria to the statutory test, although the use does not necessarily have to be for 20 years or more. A Section 36 landowner declaration has been filed in respect of this land. This signifies an action under Section 36 of the Highways Act, granting landowners the ability to clearly define existing public rights of way over their land. This is done by depositing a map and statement with the local authority. Crucially, any public use after this time will not establish new or upgrade existing rights of way. However, the lodging of a statement will not defeat an application where it is possible to establish use prior to the lodging of the landowner declaration. Therefore, the common law test is considered prior to the date of the landowner declaration in 1992. Users A to I have identified that there were gates along the route into Hanchurch Woods, and many contend that there was also a permit required for use on horseback. The evidence of use is relatively low, and there is a 6-year period with no recorded usage of the route whatsoever. 7 users claim to have used the section of the route marked A to B after the landowner declaration was submitted in 1992, which adds nothing to the claim. The actions of the landowner to prevent use of the route on horseback serves as evidence rebutting the presumption of dedication, indicating their lack of intention to allow such use. It is officer's opinion that the common law test will also therefore fail in respect of this section of the route marked A to B. So moving to the section of the application route marked B to C, both the statutory test and the common law test will be considered. The land in question is unregistered at the HM Land Registry. The date of the application, 1996, is considered the date of challenge, and therefore the relevant 20-year period will be from 1976 to 1996. As outlined within the report, the 14 users do show a degree of consistency of use of this section of the route. When added together, there are 2 users who satisfy the test of use throughout the relevant 20-year period. Although this use alone is not strong enough to satisfy the statutory test, consideration should be given to the issue of common law dedication. An implication of dedication may be shown at common law if the available evidence shows that the landowner has dedicated a right of way and that the public have accepted that dedication. In situations where an unregistered track exists between lands with registered title, the ad medium filum presumption is invoked. This presumption, meaning up to the middle line in Latin, presumes ownership of the highway subsoil to extend halfway to each adjoining property in the absence of any evidence to the contrary. As with the statutory test, the use must have been as of right and without challenge and enjoyed by the public at large, all of which appear to have been satisfied in terms of this section of the route. All of the users claim to have used the route on a regular basis, and landowners of the adjoining land claim to have seen members of the public accessing the route on a daily basis, either on foot, horseback or cycle. The landowners adjoining the application route marked B to C have not taken any steps to prevent access to the route on horseback prior to the application date in 1996, and some contend that they consider the route is a public bridleway. The use from 1969 to 2020 has seen no interruption, quantified by no challenge until the erection of the Kissing Gates in 2020, which is explained further within the report. Your office has considered that there is sufficient evidence of use to support the claim that the path is a public right-of-way in respect of the application route marked B to C under the common law test. Turning to the historical evidence, the 1910 Finance Act map is suggestive of higher rights over the northern section of the route marked B to C. On the contrary, the map doesn't support claims for the section marked A to B. While the 1986 Ordnance Survey maps colouring and linked to Bridleway 9 Whitmore raise the possibility of higher rights on the northern section of the route, these are not conclusive. Officers obtained a copy of the parish survey card and supporting correspondence relating to Public Footpath 18 Swinnerton, which can be found at Appendix I. Following the National Parks and Access to the Countryside Act 1949 survey, The path's public status was ratified with its inclusion as a public footpath 18 Swinnerton in the definitive map and statement. The record card details the route and confirms its public use for over 20 years. Notably, no objections were received regarding the inclusion of the route with the status of a public footpath. Officers also examined the parish survey card for Public Bridleway 9, Whitmore, which connects with Public Footpath 18, Swinnerton, near Acton Hill Farm. Initially recorded as a footpath, following the National Parks and Access to the Countryside Act 1949 survey, the status was questioned due to the mention of motors on the record card, and this detail prompted the upgrade, and the route was subsequently added to the definitive map and statement as a public bridleway. Following informal consultation, the applicant, via their representative, responded to indicate that they agreed with officers' conclusions contained within the report, and no further comments have been received from landowners. The application is made under section 53(2) of the 1981 Wildlife and Countryside Act, relying on the occurrence of an event specified in section 53(3)(c)(I) of the Act. That is, where on the balance of probabilities, the route should be shown on the definitive map and statement with a different description. That is, whether or not the route should be upgraded to a public bridleway. To conclude, it is officers' opinion that the user evidence submitted in respect of the application route marked A to B is not sufficient to meet the common law test, as there is insufficient evidence to show that the route has been used uninterrupted for a significant period of time, or that the landowner had dedicated the route for equestrians. It is also considered that the historical evidence does not support the contention that the section of the route marked A to B had any higher rights over it than those currently recorded. It is further considered that there is sufficient evidence of use to support the claim that the application route marked B to C is a public bridleway under common law. The historical evidence further supports the contention that the application route marked B to C carried higher rights than that of a public footpath. Officers recommend that an order should be made to upgrade the section of the application route marked B to C to the status of a public bridleway for the Borough of Stafford to a minimum width of 3 metres. Thank you. I'm happy to take any questions.
Thank you very much. When you look at the report, there's an awful lot of evidence there that you've collated, so well done with that. Members, do we want to say anything on that? Carolyn?
Firstly, thank you for inviting me onto this panel. I absolutely enjoyed the training. It was most fascinating. So very pleased to be on here. And looking through the reports, you learn a bit of history about the place. It's absolutely fascinating. And anyway, you've just mentioned that the recommendation is to keep it at 3 metres, the footpath, but in the recommendation on the paperwork it said width of 2 metres. So I'd just like to ask why the 3 metres, not 2 metres. Maybe that's to do with it being upgraded. But it also says in the report about no trees will be cut back. Is there any trees in this way, in this what's it called at the minute? Bridleway, footway, whatever it's called at the minute. Is there any trees in the way that need to go, or which one overrules anyway, put it that way?
I'm not quite sure if I've mentioned about trees within the report. I think that might have formed part of the complaints that was made back in 2020. But that the trees on the route wouldn't be considered at this tribunal of fact. It's whether or not the route needs to be upgraded. So that would be dealt with our rights of way team, depending on what decision was made today at panel. So officers, it should be 3 metres. It's a minimum width for a field-end bridleway, so it needs to be at 3 metres.
Thank you. Just getting my head round these reports.
No,
but
that's fine. Thank you very much.
The rest, absolutely agree with. I really enjoyed reading through it, and bit by bit I'll get there with the distances and things. So, yeah, no, I happily recommend this to be upgraded from B to C as a 3-metre bridleway.
Thank you, Caroline. That's your proposal. I think the 2 metres is the footpath rather than the bridleway, isn't it? So it does get. There's an awful lot of evidence in there, and occasionally you do pick up that there's different sizes, and we are as a panel entitled to say we don't think it should be that wide. It should be a different width and propose it. So sometimes we do that if we feel that there's a need. Paul.
Thank you. As a quasi-judicial panel, we've got to go with the evidence. The evidence is there. But the 3 metres, I mean, you're a farmer, we've got horses. You need 3 metres for horses, really, when you're riding, if you're riding side by side. So it should be 3 metres, I agree. The evidence is there, as it says. There's parish surveys, there's Finance Act, there's everything in there. So I will go along with Caroline, second this, that A to B is not accepted for upgrade, but on the evidence is sufficient to upgrade B to C.
Thank you. Could I just ask, where A to B is obviously, as you mentioned, it's Hanchurch Woods, it's forestry. How do people access B to C? Is there an access to it?
So currently B2C connects with Public Bridleway 9 at the northern end of the route. At the moment, Public Bridleway 9 Whitmore ends at Public Footpath 18. So B to C would then form part of the main highway on the Public Bridleway route.
But it is a cul-de-sac now, or will be.
So Public Footpath 18 isn't, however Public Bridleway 9 Whitmore is and stops at Public Footpath 18 Swinnerton.
Thank you for that. David, no? Okay, so we've got a proposal and a seconder. I'll just read it out, I think, because it's quite complicated. The recommended option is to reject the application in respect of the route marks A to B on the attached map, and to accept the application in respect of the section marked B to C on the attached map. There's obviously a little bit more around the definitive map statement. Are we happy to take the officer's recommendation? Okay. Thank you, Laura. That's we'll go with your recommendation and move forwards on that. Okay, thank you. And it has been a short meeting. We'll move on to exclusion of the public. I'm not aware of any matters. No? Okay. So 20 past 10, just about. Thank you very much for attending. Wrap up warm as you go home and drive carefully. Thank you.
Thank you, Chairman.